Okay. We still have people joining us, but we wanted to go ahead and get started on time. So we want to welcome you to What You Didn't Realize You Didn't Know. And this is part one of our three-part series on human resources. So today we have Renee Galeotto as our moderator. She's back. We also have Susie Lemon, who is the Chief Executive Officer of Dynamic Corporate Solutions. And we have Sarah Laboranti, who is a Senior Consultant for Dynamic Corporate Solutions. So welcome. Thank you so much for joining us. And we hope to get to, we got a lot of questions this week, so we hope to get to them all. Renee, it's all you.
Sarah, so everybody's been introduced, so I want to say that, you know, HR is something that everyone struggles with, I think, particularly in our industry, because we're more mechanically inclined. So that paperwork piece is something that we often need help with. And so that's why we brought you on tonight. Hopefully we'll get some answers and maybe have you back on a later date to explore some more things, because I know we're just going to scratch the surface this evening is what we're going to do. So first thing we wanted to get into is the idea of social media. And I've seen some more things in the news recently about social media becoming an issue with hiring and sometimes also getting people fired. And so I wanted to talk about how social media has changed, how we function as owners and managers, what is allowed with regard to the information that's posted on, let's say, Facebook, which is probably the most used social media platform out there. And I know there's been some discussion among us about using Facebook and looking up people's profiles who maybe they've applied for a job or maybe, you know, they've come in or something to gain more access. So I'm going to ask you, Susie, where do we stand with that? Is that something we can do, or is it something that's we should stay away from? Is it okay?
I think I saw something on social media the other day that said, "Don't let me read the comments. Don't let me read the comments." Because of course, when you start reading the comments, then your blood pressure goes up and you feel compelled to engage with the person. And of course, right now we have a pretty volatile country for many different reasons, and the fact that people are cooped up at home doesn't help. But social media has been in the news for a long time in the HR world, and lots of different lawsuits about it. And so just if we start at the beginning with, you know, pre-hire, right, when you have an applicant, you know, one of the things you've got to, is it okay? Is there a law that says you can't go on social media and I can look up Sarah Laboranti's profile and see what she's got on there? There is no law that says you can't. Am I correct, Sarah? Just jump in if I'm not correct. And yet you have to think about, there are lawsuits where people have been sued because the information they got on there was discriminatory. So you find out somebody goes to a church and you don't like that. So it's a religion issue or a race issue or something like that. So you have to be careful about it. So we normally don't recommend that you do those kinds of checks, but we do know that everybody does them. You have to be careful with the information you use. There's been a lot of court cases where people have been sued based on the information they got off of social media. Jumping over to and I'll let Sarah, although she's on mute, Sarah jump in here and talk about, you've got employees posting things.
Okay, full disclosure, something must be out there and my dog is going crazy, so that's why I'm muted. I apologize for that. The kids. Welcome to 2020. You know, you talk about rights of employees that can post things. Let's go back for a minute and think about the National Labor Relations Act, whether or not you're unionized, you're union or non-union employer. What it really comes down to is the fact that employees have certain rights to be able to vent about their job or about their company. Sorry, I'll deal with that in just a moment. People have, you know, we call it the water cooler talk. You know, they sit around the water cooler and say, "Oh my gosh, can you believe what Susie made us do today? She's making us work overtime, she's throwing overtime away." You know, that transcends into the same rights as being able to post and feel about our me on Facebook. Can I terminate them? And the answer is really, that's protected speech that they're able to go put that on there. Now, again, as Susie kind of alluded to, there's times that people will post things that, again, they could say, I want to vote for this candidate because, they are trying to increase the minimum wage. Well, again, that, political conversation actually kind of goes into the workforce to talk about that protected right when it comes to, protected bargaining activity under the NLRA, the National Labor Relations Act. So again, employees have those rights.
Well, let's explore
Yeah,
a little
so
bit.
I think the part that maybe you didn't hear, Sarah, you're cutting out for some reason, is that all companies are covered by the National Labor Relations Act. So even if you only have 2 employees, you're covered by it. And what it protects the employee is they have the right to complain or comment about conditions of employment. So they have the right to talk about how much you're paying them. They have the right to complain if you're mean and you make them work in the heat. And that carries over, like Sarah said, into social media. So if an employee was posting something about your company as being a bad place to work, then that might be gray. If they posted something that said that you treat your employees like slaves and you don't pay them enough, then that would be protected. And the court system has even allowed an employee to be reinstated that used the F word to describe his manager and his owner, because the F word was a common word used in the workplace. How about that one? And it was commenting on the conditions of employment. So social media, we actually have a whole 1-hour class on this, is fairly complicated. The safest thing to do is not to knee-jerk. A lot of the court cases are where somebody knee-jerked and fired somebody because somebody came in and showed something that was written about them and they just terminated them. The other thing I would say is that we don't, and I keep saying this during COVID, we need to have a great deal of grace for employees. People are under enormous amounts of pressure. They may work for you, but they may have a spouse that's lost their job, or they're worried about elderly parents and things like that. And so I counseled in the early days of this social media thing, I counseled a woman business owner who wanted to fire a young employee because she was putting everything out on Facebook. I said, well, it's kind of like we used to have diaries with the little, you young people won't be able to relate to this, but we had a diary and you hid it from your brother and you had a little lock and you put it under your bed. Well, now if you have a bad day at work, you put it right out on Facebook, and young people don't think about the consequences, and how that affects your business. So, and they don't think about the ramifications. I see a comment there from Thomas. That's absolutely true. They don't. And so, I would talk to the employee about how that affects our business and how if we don't have enough business, then, it's hard to keep everybody busy. And, and sometimes young people don't even think about that. And they just put everything out there because that's their means of communication with their friends and other people. But
it's very commonplace now, but
very much so.
And I know there's 1,000 or even a million scenarios out there, but if we looked at a situation that, and I've heard of this situation as well, where the employee posted something that directly insulted a client of the business and put down their product. So, as an owner, if my tech is putting down one of my OEMs or one of my equipment manufacturers, I have a huge problem with that. And, so I would want to know that I was in good standing, if I had to or felt like I had to take action. Because obviously you can't stand back and just allow that to be the case.
And you might want to write that employee up and give them a warning, or you could probably even terminate them for that. It depends on what exactly is in that posting. Like I said, if it talks about terms and conditions of employment, but it's people are being fired for their political comments, things like Black Lives Matter, support or not support of the current president, or they're a Trumper or they're a Biden person or whatever that is. You need to be very careful with all that. Some states have laws. So the thing with HR is it's not black and white.
Right.
You got federal law, you have state law, you might have municipality or local law if you're in a city that has laws. And then the other piece of it is court cases that set precedents. And so navigating all of that, you can't tell people how to vote in most states. You can't prevent them from voting. You can't tell them who to vote for in most states. And if you do, it's illegal. So then, let's say they posted something for a candidate you didn't like, and then they get fired. Maybe even they get fired for something different than that, but they just made the posting and they know you don't like that candidate.
Yeah.
You can see how that can be a mess. So you got to be careful with all that.
Yeah, of course. So what about, this was actually another part of questioning further down, but I want to bring it into the social media aspect of it. So explore a little bit and talk about for us the idea of sort of harassment that would go on either between employees, let's just say between employees on social media, where it's outside of your office, it's no longer in your walls, but it's going on. So as an employer, where do we stand on taking action, or should we take action? Or, it's kind of a dilemma. So talk about that with us a little bit.
I'll let you go on that one, Sarah. That's a good one.
Okay, sorry about that. Can you all hear me a little bit better with my headset on?
Perfect.
Renee, you jinxed me because I'm getting the storm today now. It's popping up right now. So I bet you that's all of a sudden what was happening there. So yes, that's funny. I actually taught a 4-hour compliance training class today. So again, those of you that are sitting through 1 hour voluntarily, thank you. Imagine what it was like for 4 hours. But we got onto this topic today talking about sexual harassment in the workplace. And when it comes down to harassment and sexual harassment, it is an employer's responsibility to provide a safe workplace for their employees. So think about those policies that we have in our guidelines that say, you cannot make sexual comments to someone, you cannot be violent or threaten someone. Those same rights transfer to remote workplaces. Susie can't call up and threaten to kill me over the phone, even though she's not physically in front of me. If someone, and I've had it before where I've seen this, that people are sending, stalking messages, calling people after hours, posting inappropriate pictures or saying inappropriate things or threatening things to them at work. So yes, you're exactly right. Those policies apply to anyone in any situation. So I always say within the walls of your organization, outside the walls of your organization. So if it's a client or a customer harassing or threatening your employees that are physically out, if it's an after hours party, specifically for work, or if it's happening in a virtual environment, it all needs to be treated with the same urgency.
And in the appliance business, a lot of your employees are males and don't think that they won't be harassed by females. And, we have the responsibility as employers to make sure. So, sometimes, and especially men, are not going to complain about, every time I go to Mrs. Robinson's, how about that for a name? Mrs. Robinson's house, she tries to touch me. How about that? I don't want to go to Mrs. Robinson's house. Or they won't tell you that she was rubbing up against them or whatever that might be. They might just say, I don't want to go to Mrs. Robinson's house again. I'm like, well, that's your job. You have to go where we tell you. Well, watch for some of that subtlety too, because those can be harassment situations. And we have to be very careful as employers, because the law essentially, and this is common law going back to Britain, we should have known. right? We have the
Mhm.
responsibility of knowing. And sometimes employees can be intimidated and won't tell you for whatever reason. And you've got to be watching for the body language and those kinds of things. And I can see it happening as you go out on location places too.
Sure, sure. And here's a dilemma that I run into personally, because if I see something, like you said, you should know. And so if I see something in an employee that puts up a flag for me and I bring them in and I'm talking to them, how much am I allowed to question, before it starts to become, an invasion of privacy? Because I sort of tend to stand back and I'll say, you don't have to tell me anything you don't want to tell me, but just know that I see, whatever, a change, and I just want to make sure that we address it. Where's that line? How do you judge that line where you're still doing your HR due diligence without trying to be too invasive of their privacy and, violating the HR?
Mm-hmm. So just to kind of add on to that, now just to be clear, you're talking about someone who you feel like may be being harassed, but they don't want to share kind of the full details. Is that
exactly? Yeah, or anything. It could be, that you see a change in an employee, their morale is lower, you just don't know what's going on, so you bring them in to find out. But through the course of this, if they're too closed up, I mean, at what point are you being invasive by trying to get them to open up?
Okay, great. And actually, I'm going to tell you that really seems to be a common situation these days that I'm seeing, specifically when it comes to mental health from the crisis and the pandemic that's happening to us. We had someone not too long ago, and they said, look, I feel like, and I think this is kind of what you're alluding to, they're just acting different. Something might be going on in their personal life. They might be physically dealing with some kind of medical issue. Maybe it's something like that. And you're right, there's only so much that we can do if they're not willing to be able to take that help. This may sound a little cold, to me, but when you sit down and you say first, as a leader, hey, I'm noticing, what are the work-related behaviors that you're seeing? So, they're, less engaged, less, maybe showing up for late for work. So again, number one, what are those work-related features? And number two, how is it affecting their performance? So, if someone's not as, as engaged lately, but they're still showing up and they're doing their work every single day, there's not a lot that we can do. They're meeting the performance standards. You can remind them that we've got the EAP and there's things here to help. But I always say it's kind of like with ADA, you can't assign someone a disability. So you can't tell someone that, hey, you obviously have this going on when they haven't brought it to you first. So that's something to kind of think about when you are working, with those employees also. And unfortunately, if it is affecting their performance, that's where you need to come in and say, these are the performance-related features that I'm seeing, and document that. So again, we may think that there's something going on with the employee, but at the end of the day, as a leader, we have to be responsible for documenting, late 7 times this week, 2 days didn't show up at all, getting customer complaints, not returning calls, those types of things. So then when you sit down and you bring up these performance issues with them, and then sometimes employees will kind of say, I do realize my performance has been going down, but this is what's going on. And then maybe at that point, that's where you jump in and say, okay, let's talk about this. Do you maybe need some time off of work? What are some resources that are available to you? That's it's sticky one because each situation is a little different. And Susie, I'm sure you'll agree with me. Everything, there's so much gray area in each of these situations. It's one of my roles is I spend a lot of time dealing with each of those. Go ahead.
Yeah, Sarah's on a helpline that we have for small business owners, and where they call in and get advice. And one of the things I wanted to mention too was it's important as a manager that you ask open-ended questions like, hey, I noticed that there's X going on here. What's going on with you? And then the really hard part is to be silent and let them talk.
Yeah.
And that's, that's hard for a lot of us. I mean, we want to just, well, you're doing this, you're doing this, you're doing, how about like, hey, you normally do a great job and there's something's changed here. What's going on with you?
So,
Yep. And if I could jump in, go ahead. I just have a quick story on that one. Keep it work related. That's really my biggest piece. And I'll tell you, years ago, I saw it happen at another company. It wasn't one of my clients, but it was a new leader. She pulled the employee in and said, hey, you haven't been that happy. What's going on? I didn't give you as high marks this year. I really noticed that you've gained a lot of weight in the last 6 months. So,
Oh gosh.
so again, keep it work related, as it's how is their change affecting their specific job. Don't bring weight into the evaluation.
please don't bring weight into the evaluation.
Thank
It sounds simple, but yeah.
Yeah.
Go ahead. Sorry, Renee.
Never, weight and age, no, let's stay away from those. To change gears just a little bit, I want to talk about screening, background checks, drug screens, and that sort of thing. So we've moved away from the social media, the aspect of it being very public, because my thought process was, if it's out there for everybody to see, how is looking at it that different than doing a screen process? Because you're still looking into those personal pieces of information that impact your business if you hire them. So speaking in relation to things that are changing in our country right now, I want to particularly talk about the legalization of marijuana in different states. Because it's become a question in my mind, because we screen for different illegal drugs, but they're illegal in my state. They are not illegal in every state. So talk to us about how owners now are treating that when you have an employee, and maybe it's a part of the screen, maybe it has to be a part of the screen for whatever reason, but it's legal there. They popped for marijuana, but it's legal there. What do we do at that point? How do we address that?
Well, I mean,
Susie,
and
I know
I'm
you're
going to
gonna
let
send this one to me.
Sarah's she can always tell I'm dying to talk. Sarah's actually our expert on CBD and marijuana. So we have medical marijuana here in Florida where we are located, but we have clients in all the states. So there's different state laws that apply. The one thing that, don't forget, it's federally illegal, which makes it really, really complicated, but not so complicated from the employer perspective. From the, you can still test for marijuana and have a drug-free workplace and say you're going to test for marijuana. And if you test positive, even if it's legal in your state, you can be terminated. And I'm going to let Sarah get into all the details. Now, CBD oil gets really complicated because that will pop on some drug tests, and on some CBD products won't pop. And then your naive employee is going to go get some cream for their knee, and because somebody thought that it would help their knee problem, and then they get a random drug test from you, and it pops positive, and they're confused about that. And so it does really make it hard for the employer, but I'll turn that over to Sarah.
And Sarah, before you get into it, let me say and put this out there. Let's just say that I'm your employee and my drug screen became, I needed to go do it. It was time, my 2 years or whatever, my time frame was up. So I'm going for my regular drug screen. And I popped for marijuana on that day, but I wasn't high. That was something, we're in a legalized state, and that was something I did 2 weeks ago, but it's still in my system, so here we are. But I didn't violate, I wasn't high when I came to work. So where do I stand?
Okay. Great example. I'm going to go high level for just a moment and then get back to your question. First of all, Susie, I'm going to not even talk about CBD right now, because that's probably like a part 4 of this series. That's a whole other ballgame. Specifically, exactly, I think what all of us know is that even though marijuana is federally still considered illegal, which again, that means that THC is considered an illegal substance on Scheduled 1 narcotic on the list. Each state looks at this a little bit differently. So as we know, just in general, like for example, in the state of Florida, medical marijuana is legal, so there's state laws. But also, there's a second piece of this, which is what are the court interpretations in each state. So I will tell you, number 2 is even though medical marijuana is legal in Florida, the protections, because of the court cases, lie with the employer, which means an employer can still have a stronger policy and say we're a drug-free workplace. You can't have marijuana in your system at all. And if you test positive, you have a positive drug test and you can't work here. Other states that have medical marijuana legalities may have case precedents that give rights to the employee. Now, when you're talking about states, Renee, getting back to your question, it really is going to be dependent upon your state. As some of you probably know, in New York City, and that's not the state, but that's the city, you are no longer even allowed to drug screen random or pre-employment for marijuana. They've actually taken it right out of the panel, so it's a 4-panel now. So number 2, what I would do is think about number 1, which state are you in and what are the legalities of that. There are some states that don't even allow you to test somebody. There are states that allow you to test, but only in certain situations. Most of the time, these allowances are for reasonable suspicion. So just to say, hey, I'm testing you for the point of testing you, pre-employment or whatever, there really is nothing you can do with that information, Renee. So again, it's going to be dependent on the state laws that you are in. My recommendation, and this is just to give a little background on our HR toolkit, with our HR toolkit and helpline service, you actually get a link to our system that tells you all the rights specifically in your state that you're employed in, because it's really difficult to be able to talk about, you know, legalities when you're a multi-state employer. So, you know, you may not even want to test for that anymore if your state will not allow you to do anything with that. As another caveat, there are some states that are now starting to look at whether you can use medical marijuana as a reasonable accommodation. So to say that someone has pain in the off hours when they're not at work, you know, if they got injured at work or they have a back injury, it's an ADA issue, sure, they can, you know, use the tinctures or certain forms as an accommodation. So think about that. I personally think that in another year or 2, if you invite me to come have this conversation, the answers are going to probably be even different and probably, you know, may look federally. But Renee, one more thing to go towards your question, and I know you have lots of questions here, so I won't elaborate too much, but what's one thing that's really important to understand at the end of our day is that no law, no state requirement or court case allows people to be high at work. So what I really encourage employers to do is take a look at your policies and not focusing so much on those drug tests, but what are we doing for reasonable suspicion? You know, do we have a good process in place that if I smell it when you come into work, if you're jumping on a forklift and you seem like, you know, you look buzzed, your eyes are red, you're walking sideways, you know, that is where I am, from an employer side, we really keep our control. So again, I know that was a long way of answering your question, but a lot of times, you know, if the protections are with the employee and they have the right to do it in their off time, there's not much that you can do as long as they're still physically able to do the job and they're not under the influence at work. And again, that's a real general answer for one of 50 states.
Yeah, exactly. So that brings us to the question of, and this happened to me recently, I was asked, one of my employees injured himself on the job. I sent him to urgent care. They immediately said, do you want to do a drug screen? So my answer was, I knew exactly what he had done. I knew he wasn't operating the vehicle when he did it. I waived it. I said, no, I don't need to do it. Should I have a drug screen every single time one of my employees is involved in anything like that? Whether it be a car accident, fender bender, you know, whatever's going on, they cut themselves, whatever. Should I have that drug screen regardless?
I would really look at your policy on that. I used to be like that years ago. I worked in healthcare. Anytime anybody had an injury, you know, we tested them and finally said, you know what, this is getting excessive and expensive, and it wasn't giving us the right results. Couple things before I say make it dependent on the situation. Number one, make sure obviously you're checking with your workers' comp policies. And number two, make sure that your decision whether to test or not test doesn't have a disparate impact, which means you're maybe discriminating against, you know, a certain group. You're discriminating against a minority group, a group of, you know, only people that are over 40 or something like that. So what I would recommend is you write those policies to say, I would test if I feel like someone was, you know, if the accident was their fault, if it resulted in an injury to another person. So again, you could have different parameters. I'm not a big advocate of making sure we have to drug test everybody, but what you don't want to do is pick and choose. Yes, 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 I know what he does after work. No, it's fine, I trust him, just to make sure that we don't end up with any practice of discrimination.
If you're subject to the scrutiny that might be out there, wouldn't it be just safer to say everybody's going to do a drug screen, period? Because I mean, how do you judge, you know, later on, when you're doing things randomly and accidents occur very randomly, and it may not look like a pattern at the time, but later on it does look like a pattern, would you be better off just to say, let everybody does it, period, and be done with it?
That's obviously the safest thing. I mean, if you're looking at risk mitigation, there's much less risk if you know, test everyone after that has an accident than there is if you make even at whatever criteria, because if even that criteria that is neutral in appearance sends all the Hispanic employees or all the Black employees or whatever for tests, and all the white employees end up not getting tested, you know, that could be grounds for some kind of a lawsuit.
Right. So just everybody who's in a car accident, for example, or everybody who's in a fender bender, everybody who's issued a citation traffic, drug screen, but anybody who cuts their hand, maybe no. Would that be something permissible, or is that still trying to walk that line?
I think you as a business owner or as a manager of a business you have to decide, because obviously if it's $50 for every drug screen, I mean, it could put you out of business. The other thing you've got to look at with safety issues is, why are you having so many accidents? And do we need to do more training, which I think the association could probably help you with, you know, what's going on here. You know, hopefully you're not going to have that many accidents, and it's not going to be that expensive.
Well, going into in a little bit of a different direction. Drug screens are expensive. I'm glad you said that, because it brings me to another question that I had about this. When hiring, okay, with respect to the random drug screens and things like that, if you screen a pre-employment drug screen, here's one of my biggest pet peeves, and I'll let you field this one when I'm done. I'm going to hire somebody. I'm going to screen them. They know they're not going to pass. They're not going to tell me this, but they know they're not going to pass. And they go anyway. And so my $100 was just blown by somebody who knew they weren't going to pass, but they, for whatever reason, wanted to save face, which is not in any way saving face when you fail your drug screen. So is there a part of the interview process where it would be permissible for us to say, if you feel like you're not going to pass the drug screen, just turn down the offer and we'll call it a day? You don't have to tell me anything else. I don't want to put $100 out there for you to go and blow this drug screen. You know, it amazes me why anybody would show up. So what do you think? Can I say to them, you know, please don't waste my money, if not in those words, but basically, can I put it out there and say, if you know there's going to be a problem, just don't go. We'll call it a day. It was good to meet you, you know, this kind of thing.
You can certainly do that. It probably won't be that effective because the person that's going to go get a drug screen and just did coke or whatever, they're obviously clueless. It's interesting. I was on a not-for-profit search committee, and we told every single applicant, we're going to do a credit report. We're going to run a credit report on you, and, you know, let us know if there's anything that we should know. Oh, no, everything's fine. And then invariably it comes back with, you know, we had one embezzler, how about that, that had been convicted and gone to prison. That was a good one. After we told them, they didn't disclose it. We had one that that had all these charge-offs and a bankruptcy, and they didn't disclose it. So I don't know if that's just human nature or what. They just think it'll slide through, or they want the job so bad, or they're just clueless. I don't know.
Sure.
The good news is you find that out before you hire them.
Well, you know what? It's one of those, it's almost like a trial by fire, because you think you've got a good solid person, and maybe they are, maybe they just messed up, you know, over the weekend, or they forgot they were coming for a big drug screen on Monday morning.
My brother-in-law brought some brownies over to my house. I didn't know what was in them.
There you go. Yeah, it was.
I heard that one. I love that one. Must have been those brownies I had this weekend.
That is priceless. So in the hiring platform, when we're doing this, which is, by the way, one of the hardest things I think that we do as owners, is try to hire employees and choose that person. What information, and I'm speaking paperwork, and I know this is probably going to vary a little bit by state, but what information, what paperwork do we need to gather every single time? Because you know, still with the drug screens, I'm gathering a consent form to drug screen and some other stuff. But you tell me, what things are we, you know, supposed to be getting that maybe we don't realize we are supposed to be?
Well, I'll mention a couple things, and then Sarah, you can jump in. You know, one thing that I like to get on every single applicant is an application.
Okay.
I mean, that seems kind of silly, but sometimes, you know, somebody gives you a resume, you don't have them fill out an application. You should have a really good application. Now, keep in mind, in some states, you're not allowed to ask certain questions on applications. So you need to be aware of that and not ask those questions that you shouldn't be asking on the application. But I like applications because on the second page, you have a lot of little fine print that says, if you lied on the application, you can be terminated. You know, everything I put on here is true, and an employment at will statement is also on that application that says I can be terminated anytime for any reason, and then they sign it. So even if they don't completely fill out the application, you definitely want them to sign that. That's one thing that you absolutely should get. Another thing that it would be illegal for you not to have is an I-9. And so that's the immigration form that says they can work in the United States. And there's numbers of rules that go along with the I-9 form, and you need to make sure you don't violate that. Like, just one rule is you can't tell them what IDs to bring. You can't say, hey, bring your driver's license, your social security card. You know, it's one from column A and one from column B, or a passport, or whatever that is. So, or a green card. So those are some things that you absolutely have to have. What other things, Sarah?
If you're running a background check, one of the things that you will want to make sure you have them sign is the release for the criminal background check. A lot of us, you know, send out this letter and have them sign this form, but we don't really understand the laws and the employment laws of the implication. The Fair Credit Reporting Act actually has a series of 3 letters that are available to us that you are required to send to a candidate to notify them that you are making a decision on their employment based on the information in that background check. So the first one is just a verification that says, yes, I give permission I understand that part of my decision for employment is going to be made on this. And then the second letter, if you go through, is basically a letter that states, you know what, something came up on your background check. We need to have some information. So it says that we may be holding this, you know, the offer, we may take it back based on the information. And then the third letter in that Fair Credit Reporting Act packet is, you know, we've decided not to hire you. So I always say, going back to the original question, make sure that you follow that step one to say, we are going to be, you know, we've made you the offer, but you're not hired yet until we get the information back from you. So I always make sure and have that release completed also. As Susie said, just like the application, it gives us the rights to make a decision because you lied on something or you didn't give us the full details. So we've got that covered also. You know, other things that are required are obviously the W-4 form for anything that requires, you know, your tax information to get hired for your employees. The other things that are really the nice to have when you go through, and this really goes into the onboarding, and I actually have a whole kind of checklist in the packet that talks about, you know, are you having them sign all your policies from the handbook? Do you have a handbook with policies for them to understand? Because once they get going, if you have any employment issues come up, you've got this signed handbook to fall back on. Are you having them sign a confidentiality agreement saying, you know, the information that I see, the proprietary systems that we use, they're not going to take those and run to another company also. So some of it's going to depend upon the industry that you're in. The one other piece I will add is I really kind of talk to people about there being 3 separate parts of the employment process. So number one is kind of the pre-employment process. So again, that's where you get the employment application. You can't ask for certain things such as their, you know, their their date of birth or their social security number. The next phase of that offer process is the post-offer pre-employment. So you've already made the offer. You want to run their background check. That's when you can start asking for their date of birth, their social security number. You know, maybe they're going to fill out this, you know, identifying information for EEOC. So always make sure that when you ask that information, I've seen it before, I'll go somewhere and they'll have a packet to every applicant that says, what is your date of birth? What is your social security number? You know, are you black or white, male or female? And say, well, I'm going to need that information. You can only ask for that information once you've made them the job offer, not during the interview process. And there's a lot of people that just put that all together in a packet and say, here, just fill all this out just in case we hire you, to make sure that you're delineating when you ask for what information.
Right. So Susie said something interesting to me about the I-9 request for identification. So you said you can't tell them to bring the driver's license. You're just saying that as an example, or I can't, because I need to, and all of us who have technicians who are on the road driving our vehicles or otherwise have to make sure that they have a driver's license. So doesn't that go hand in hand with asking them to present one?
I was speaking about the I-9 form specifically, where you cannot tell them what documentation to bring. They have to bring documentation.
To prove citizenship, you're saying.
To prove it, right? But
okay.
So you separately, if you're going to have someone drive, then that would be a separate from the I-9 form.
I wanted to clarify because I was thinking that might be specific to the citizenship piece of the I-9. So some of the questions I had before we came into this was with hiring new hires in our industry. A lot of times we're training technicians from the ground up, and so when you're building a technician and you invest a lot of money, and it does cost us quite a bit to get a trained technician on the road who's productive. Can you build into your process some sort of contract or an obligation to that employee so that he or she doesn't get trained and then immediately leave you and go out on their own? Is there a way to protect yourself in the HR world from that kind of eventuality?
Depending on what state you're in, you may be able to do a non-compete agreement that where, for a certain reasonable period of time and for a reasonable geographic area, that you could restrict their ability to go work in it for a competitor. But in some states, some states disallow those agreements and some states allow them. So that's one thing that you could do to protect, just like what the non-disclosure agreement that Sarah is talking about, you should have for all employees so that they can't take your customer lists and give them to your competitors. The other piece of it, though, is that what can we do to build, and I guess as opposed to a punitive approach, which the non-disclosure would be, a more positive approach at incenting someone to stay and building maybe, once you get this certification, then you're going to get $1 raise or 50 cents or whatever you can, if you can build a system like that. It costs a lot of money to hire an experienced tech. If you're going to train the tech, then you don't want them to leave. Can you build some extra pay or some other kinds of incentives in there to keep them wanting to stay with you, as opposed to get trained and then go and be able to jump for more money? So those are things that you could build in from an incentive perspective in your compensation to help keep them.
What about building in a piece that would allow you to recoup some of the costs of the training should they up and decide to leave immediately following completion of training or when they become established on the road?
I don't want to make the blanket statement that you can do that in all states, because I know in California, I don't know if we have anybody on here from California, but there's very specific rules on final pay, and other states have those. So given state law, the one thing that you absolutely cannot do and that you need to think about is if you have uniforms and you're charging employees for uniforms, you can never, ever go below minimum wage. And it's interesting, Chick-fil-A just got in trouble for this, where they were charging, I guess they have their little polo shirts that they wear at Chick-fil-A, and they were taking it out of people's pay, and it brought them below minimum wage, and they're getting sued for that. So that is absolutely not allowed. But you could build some of that in depending on what state you're in and if that's allowed. But as long as you didn't go below minimum wage.
Sarah, do you have anything to add to that? I heard you.
She was breathing.
Yeah, she was like, she's correct. So,
I would just say if you decide to really do something like that and you do the research, make sure they sign that up front. I understand that the amount of this training program is X dollars, if it's some kind of formal in-house training program versus, hey, we're mad because you're leaving, so now you owe us money back. So again, I would make sure if you do that and your state allows it, that you're very clear about that up front.
Everyone who's in business for themselves should have a handbook if they have employees. True?
You should only have a handbook if it's a good handbook. So if you have a handbook that's, I used to say a year. Of course, after a year of 2020, it might be less than a year. If it's not compliant, you should throw it in the trash can. Because a bad handbook can do more harm than good. A good handbook can really help you. It's a communication device with the employee. It also helps you as an owner and a manager to think through scenarios of how you're going to handle certain things. When we started the HR toolkit, we built the ones for Florida first, and I had a guy from Colorado call me and ran an HVAC company, and he had 5 employees. I said, why do you want to buy the HR toolkit? And he says, well, Susie, this is kind of embarrassing. I hired the 3rd guy, and I told him how much PTO he got. And then I hired the 4th guy, and I'm out there fixing air conditioners with the guys and doing all that. I can remember what I told the 3rd guy. I need a handbook, which we have in our toolkit, that are compliant by state and federal law. I need a handbook so that I can remember what my policies are. So there's a lot of benefits to a handbook, but I'm serious. I've seen some horrible handbooks that you might as well just write a check when you go to court, because what they have in them is not good. So you want to have a good compliant one, and that's, one of the reasons that we, because we are so in favor of small business and promoting small business, want them to have, the same kind of things that big companies have, and the handbook is a critical piece.
We only have a few minutes left, and like I said at the beginning, this is only scratching the surface. I have about 80 more questions that I need to ask, and 10 minutes isn't going to cut it. So can we move on really quickly? I want to talk about the idea of grounds for dismissal, and what kind of advice would you give someone who has an employee who's out on a medical leave? But maybe I actually had this happen. I was going to fire somebody for performance, and the day I was going to bring him in, he called in sick and had a back issue and blah, 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 blah. And then it just mushroomed from there. So, what do you do in those situations? I needed to let him go, and now I have to keep him on, So what's your advice on that?
Go for it, Sarah. That sounds like a helpline call to me.
It does sound like a helpline call, so I'm just going to make my pitch if anyone's interested for more information, because really each situation is, there's always some gray area, and there's no hard and fast line. You're right, though, that you have the sense to say, hang on, push the pause button, let's make sure that now we're not doing anything illegal or against the law. And just a pitch to go back to Susie's question, you should have a handbook for these specific reasons, because that will kind of have a policy to go back to referring for ADA and those types of things. So let's say you've got documented performance issues, this has happened, but all of a sudden they say, you know what, the reason that I have been out of work now is because I have, I've been getting treated by a physician, I'm under, medical care, I probably will qualify for a leave of absence. This is why I haven't been doing that. It's probably to your benefit to at least get the information. That doesn't erase the performance issues. However, I always talk in terms of risk. There's a higher amount of risk now that we have this information to go back and at least push the pause button and look into that and say, okay, does this impact anything that's happened with the performance issues? In some situations, you can say, you know what, at the end of the day, you know what, you may have this injury, but, you also, beat up someone at work, so there's not much we can do about it. But again, when it comes to FMLA and ADA, those types of things, and I won't start throwing out a lot of, HR, buzzwords and everything, but it's really important to understand that as your business grows, you hit 15 or more employees, now you fall under the Americans with Disability Act requirements. So you have this onus to make sure you understand that terminating someone without considering the Americans with Disabilities Act could get you a call from, a not so friendly, attorney or investigator after the termination to say you've done it wrong. So we want to help you do it right, and part of that is making sure you have that right handbook.
So this is following up on the idea that we've terminated somebody. This is a question that comes up pretty frequently when discussing things after the fact. So they've moved on to another company, and that company calls me for a reference. What am I allowed to say?
All right, I'll take that one, Susie.
I'm typing away at the chat.
Nothing. So. I can't say anything.
You could. I'll answer this one. So I have gray hair. I have to feel like I still can remember the answers. Most companies give a neutral reference, name, rank, and serial number. That's obviously the safest thing to do. the date, their dates of employment and what their position was and little else. That's the
Right.
safest thing. If the person committed like a violent act or they stole money from you, something like that, in most cases, you could be liable for not disclosing that. So you're going to want to disclose that carefully. And if you choose to tell the truth about the person, you want to, and in some states, there are laws that protect you if you do. But if you do choose to do that, you want to be careful how you do it and only speak about things that are job related. So, that they were absent 17 times or that something that's a fact that's not disputable. Don't ever say, the guy's got a weird personality and he doesn't get along with anybody. That's a little squishy, right?
Sure.
But saying that I had 75 complaints from customers about him is different. So you want to be careful if you decide to do that. But and most HR departments just give a neutral reference. Now, if you're checking references on somebody, knowing that they're only going to give you a neutral reference, you want to, I call it weasel around and say, hey, can you just tell me one thing? Can you just tell me if he's eligible for rehire? And sometimes they'll give you more information. And you can tell from their, oh, absolutely not, right? Or, sure, we'd hire him back, and you can find out information that way. So it depends on if you're getting the request for information or whether you're trying to find out information, how you want to handle that. But the safest thing to do is just give a neutral reference.
Mm-hmm.
Sarah Brown, I'm going to go back to you. You have a question. I know you sent it to me, but I can't read it. It's a little bit
okay.
too. So if you'll go ahead and ask that
No,
question.
that's okay. It's on the chat. And it's kind of, we're like 2 questions before. Jeff Olson asked, if you offer a 4-week tech training program in-house with a schedule, can a predetermined cost be established? An example cost is $4,000. Can an agreement be signed upon hiring? If they leave employment before 1 year, are they responsible to reimburse you as the employer?
Mm.
And he also has a follow-up question if you want to think about that while I read that too. He says, also, let's say you send them to like a manufacturer training or any ongoing factory training and pay wages and travel costs. Can an agreement be made before you send them that if they leave employment, let's say 6 months prior, are they responsible for reimbursing you that cost? Is that legal?
Once again, if they leave and, I mean, what's the likelihood their final pay is going to be $4,000? Maybe it is. And then, depending on what your minimum wage is, let's say federal minimum wage is $7.25 an hour. You could, take out everything but that $7.25, and you could always do that when somebody leaves. The thing to think about is, is it fair? Is it consistent? Are you going to get in trouble with any laws? And there may be laws in your state that don't allow you to do that. Another thing you could maybe do is spread the $4,000 over the course of the, say, 10 weeks. And as long as the person doesn't go below, pay a minimum wage, plus we'll provide you the training. But then that's still not giving you any handcuffs to keep them there after the training's over. So that's why I think that your best bet is to try to figure out what you can do so at the end of the training, they're going to want to stay with you.
I think that's,
bonus,
that's always the end goal, is to keep your people in place, because it's costly to train technicians. It's time consuming to train technicians, and having them walk away from the job means you've got to start all over again. So that's the end goal. But I don't think you'll ever prevent the person who's just, ambitious as far as trying to figure out a way that whatever he's bringing into your company he can be bringing it into his pocket or her pocket. There's always going to be that person out there. And, with respect to that kind of thing, I think we're all guarded against it because it's a big gamble we take when we train a technician of whether or not they're going to be our competitor in the next 3 years. You know, and
I think that that's one of the reasons that HR is so important. And I like to think that I'm an evangelist for this. HR is critical. And, even if you're very small, putting in infrastructure and making yourself so professional and, having a professionally done handbook and having onboarding, checklists and having the documents and really setting the stage when you bring somebody new on so they feel like they've really joined someplace where they want to stay. And it starts in the application process all the way through. So HR infrastructure is really critical. And that's part of what we can help you with the different toolkits for the different states and making sure as you encounter these issues that you have somebody that you can call and not wait until you need an attorney for $400 or $500 an hour. I mean, that's our goal, is to help you grow your business. And, you can't do that if you have really high turnover. You just can't. So anything we can do to make the workplace better is going to help you in the long run to grow and be more profitable.
Well, thank you so much. I wish we had another 45 minutes because like I said, the other 800 questions will have to wait for next time. So, but thank you so much. You've shed a little light on this, and I know while we've only scratched the surface, some people got some answers tonight that they really needed. So, we
and
really
Sarah, I guess you'll send our contact information out to everybody. And
Yep, I was just going to go ahead, Sarah. Other Sarah.
Oh, I'll use the closing up webinars here. I do training for a living too. So let me just say this real quick is that, yes, I'd be happy to. I know I had some people ask for some information. I'll send that out. Also, I have some links to some industry specific training. It's completely complimentary that kind of talks about HR specific kind of topics that are hot in your industry. So I want to be able to share that with all of you also. So I'll follow up with you, Sarah, on the contacts. But again, I'm happy to come back anytime, even if you have just a few questions. There's always more things that come up. So thanks for having me.
Sounds like we kind of need a part ABC of this part 1 of 3. So thank you very much. And anything you send me, Sarah, we can put on our replay page. So we have a page that they can replay this, and then any links that you have. So thank you again, Susie, and thank you for bringing Sarah. We really appreciate it. And Renee, thank you for your time this evening as well. We hope everybody learned something.
Thank you, Renee.
And we will see you guys at our next one, which will be on October 13th, which is liability. So we look forward to that.
All right. Thank you, everyone.
Yep.
Thank
Bye.
you.